lecture E on Q. He is searching. Where is the showcase notice 2/2017?
That is at to page 289 and 290, Your Lordship.
Page 20?
289 and 290, Your Lordship. Annexure 5 and 6, Action 5 and 6, Your Lordship.
In this, there is no proposal for blacklisting?
No. Different places, Your Lordship. They are saying in generality that your contract has been debarred. Now, why not the action should be taken under Thekedar Nivandan Niyamavali 2000 under rules? And there is no specific proposal. Yes, why not your form should be blacklisted, Your Lordship? Which is the essence of law, Your Lordship, that has been settled in the Gorkha Security Services case, Your Lordship, by the Honorable Apex Court, Your Lordship.
In Annexure 6, you have been asked for show cause which
5 and 6. 5 and 6, Your Lordship. I have been asked for
प्रासंगिक पत्र को संलग्न करते हुए निर्देश दिया जाता है कि उक्त के संबंध कारण का प्रतिवेदन किया जाए कि क्यों नहीं आपके बिहार ठेकेदारी निबंधन नियमावली एवं विभागीय कार्यालय आदेश के द्वारा सुसंगत प्रावधान के अंतर्गत कार्यवाही की जाए. दिस इज अ ब्लैक लिस्टिंग प्रोविजन मिलो एंड लॉ 154. This is a specific for blacklisting below. And under this rule, it has been black. On page 44, where is the reference of providing executive engineers reasons or comments dated 1/8/2017? para 3 एकरनामा भी खंडित होने के उपरांत अधीक्षण अभियंता राष्ट्रीय उच्च पथ अंचल दरभंगा के द्वारा पत्रांक संख्या 16 दिनांक 26/2016 द्वारा संवेदक पर कार्रवाई किए जाने की अनुशंसा मुख्य अभियंता राष्ट्रीय उच्च पथ एवं उपविभाग पटना से किया गया. अधीक्षण अभियंता राष्ट्रीय उच्च पथ स्तर दरभंगा पत्रांक संख्या 16 के द्वारा संवेदक पर कार्रवाई की जाने की अनुशंसा के आलोक में विभागीय पत्रांक संख्या 187 डेटेड 16/2017 के द्वारा संवेदक से स्पष्टीकरण की मांग की गई. पुनः अभियंता राष्ट्रीय उच्च पथ बिहार पटना के द्वारा अपने पत्रांक संख्या इतना के माध्यम से अनुशंसा प्राप्त होने के उपरांत. Please don't go on reading. You just point out whether executive engineer reasons or comments have been received by the engineer in chief has been provided to petitioner or not. Engineer in chief or engineer? Chief engineer.
chief engineer has submitted this.
No, the order is passed by chief engineer. Ask him to file an affidavit. Then council, the engineer in chief who has passed the order on 15/5/2018 blacklisting the petitioner for a period of 10 years is hereby directed to file his personal affidavit as to whether petitioner has been provided comments or a report of the executive engineer received by him
Chief
on 1/8 with reference to executive engineer's report or comments dated 1/8/2017, and it has been provided to the petitioner before impugned action
is taken or not. Further, affidavit must reveal, was there any proposal for blacklisting petitioner for a period of 10 years so as to ascertain whether he has been provided opportunity or not. Accused of the concerned authority shall also take note of contents of show cause notice dated 16/1/2017 and 20th February 2017. Accused of. It is reliably learned that subject matter of arbitration award was passed in favor of the petitioner on 6/12/2017 before blacklisting the petitioner. Whether the engineer-in chief was a party to the arbitration, if he is a party in that event, why such award has not been taken note of while before passing the blacklisting order against the petitioner. Information shall be reflected in the personal affidavit to be filed. List this matter after 2 weeks.
Award is under challenge, my lord. Award is under challenge before.
Award is challenged.
Award is under challenge.
It is your every right. First you do your duty. Withdrawn.
यहाँ अगर पसंद है
Show his name.
Number 32, Western Supreme Court Section 2, the State of Bihar for Assistance Chief Vijay Kumar.
First case I am appearing, my lord. Two case. First case I want to withdraw, my lord, because grievance has been redressed.
First case withdrawn. Second case.
Second case, my lord, for the same tender, his technical bid was cancelled, my lord. Other counsel is appearing. That was challenged. And for that, work order was withheld. Now I filed the writ petition, my lord, after court's order. Number one.
No, his relief is not in so blacklisting or termination, nothing. Respect of rejection of technical bid.
Technical bid.
Same. It has already spent.
Other counsel is appearing.
technical bid has been rejected on the basis of clause.
Now the project has been completed. Finally, work order has been issued in my favor, my lord.
Appears in 18710 of 2018. In the instant petition, petitioner has prayed for the following relief. There is no interim order in the result. Subject matter of contract must have spent its force. Therefore, the present petition do not survive for consideration. Accordingly, the petition stand dismissed as it has become infectious.
Here number 33, Jitendra Kumar versus the Bihar Education Corporation.
Blood. I want to withdraw. It has become infectious.
Withdrawn.
Here number 34, Arjit Carrier Private Limited versus the Chairman and Nine Data Corporation Limited for professional fee allocation.
Lordship, one opportunity may be given for filing counter, Lordship. Earlier there was order on 19th of December. Lordship, will be filing. I have received the instructions, filing counter shortly.
Where is the 23/11/2018 order?
My lords, at annexure 21. Annexure 3, page 21. Matter was remanded back.
21.
My lords. Matter was remanded back on the last occasion. Thereafter, a recent order has been passed by the Bharat Petroleum, that is at annexure 2, page 16.
What is this allotment of
Tank lorries for supply of petroleum products, lordship, to various retail dealers. Contention of the petition, lordship, that
counter affidavit be filed before the next state of hearing? List this matter after 3 weeks.
obliged.
Zero 55 Rajesh Kumar versus Tarun Kumar for the next related Vasi.
Yes.
The writ petitioner had challenged the order passed by Learned Building Tribunal, by which the order passed by the municipal commissioner was set aside. My lord, the brief facts I would just give. One Bengali Singh had gifted 3 kathas of land to his son Shailesh Kumar, who is the appellant in the second case.
Wait, writ petition.
Writ petitioner, my lord, is respondent in appeal. He was director of Surya Nest Build Limited.
Director of?
Surya Nest Build Limited. It is a company which was inducted as 4th partner. My lord, I'll just briefly state the facts. On 23/9,
You cannot prepare dates and events.
I prepared, my lord.
Give that.
My lord. On 23/9/2009, father of the appellants in both cases, Bengali Singh, had gifted 3 kattha of land to his son Shailesh Kumar. On 29/1/2011, the 3 sons, who are the appellants in both the appeals, they constituted one partnership firm known as SRM Builders.
Wait, what is the prayer of the petitioner Tarun Kumar?
My lord, Tarun Kumar had challenged the order passed by the Learned Building Tribunal, by which the order passed by municipal commissioner was set aside. Municipal commissioner, while condoning the deviations which were found to be minor in nature, had asked the writ.
Where is that tribunal order?
My lord, annexure 1 of the writ application. It starts at page number 35. The appeal was allowed by a majority of 2:1. There is a dissenting order also. The separate dissenting order is
What is the locus standi of Shailesh Kumar before the tribunal?
My lord, Shailesh Kumar was one of the 3 landowners, and he was also a partner in the SRM Builder, which was to develop the 9 kathas of land. There was a dispute amongst the partners of SRM Builder.
whether the corporation, municipal corporation is power to condone the and proceed to compounding fee and other thing, which is the plan. So that
Patna Municipal Corporation.
Municipal Commissioner invoke which provision of law for condonation and compounding fee was allowed?
My lord, the provision is not mentioned herein, but
And without that, how to
Seven.
decide?
Section
17 of the Municipal Act, Section 317 of the Bihar Municipal Act. And a title suit is pending, in which title suit is also pending at his instance.
Suit?
Yes. In which injunction was refused.
No, first of all, whether this commissioner has power?
Yes, my lord. Section 317 of the Bihar Municipal Act 2007. 317.
Is it the Bihar Municipal Corporation Act or Patna Municipal Corporation?
Bihar
Bihar
Municipal.
Municipal Act 2007. May I pass it on? Section 7, first proviso.
हमारा पास how this is applicable to Patna Municipal Corporation?
The building tribunal has also been
It's
constituted,
relating to Bihar Municipalities Act.
covers this also.
No. Where is the Patna Corporation Act
I'll just.
or Municipal Corporation Act? How many corporations are available in the state of Bihar?
This applies to.
How many corporations are there?
It has come into force by repealing Patna Municipal Corporation. In section 488, it has come into force on repeal of Patna Municipal Corporation Act 1951. Section 488 of the same act.
Patna Municipal Corporation Act has been repealed.
No, is there any Patna Municipal Corporation Act?
Prior to 2007, your lordship. 2007, there was Patna Municipal.
Then you have to point out which is the repealing provision.
488. 488 is the repealing provision.
Excuse me. Okay, reasons have been assigned. Was there any proposal for demolition of the building?
In fact, Lord, at his instance, they were the landholders. We entered into partnership. It was a partnership dispute. They started filing applications and then filed a title suit praying for injunction to stop construction work on the pretext that inferior quality. Then inspections were carried out. Minor deviation of ramp was pointed out. That was within the condonable limit. 95,000 was the charge. The commissioner imposed 5 times, although that we paid that also. And thereafter he filed appeal. Suit is still pending.
Suit is relating to what?
Suit is for stopping the construction and for all these structures. Lord, titles.
Is there any injunction in the suit?
Injunction was refused. In fact, Lord, thereafter he filed miscellaneous appeal. That was rejected. Came to the High Court. That was rejected. Building is complete.
My lord, in this case, the municipal commissioner has it himself held that the sanction plan had expired on 16/2/2015, despite the expiry of the sanction plan to 2015. Despite the expiry of the plan, initially, my lord, Shailesh Kumar had obtained sanction of 9 kattha and 3 kattha composite sanction plan for 12 kattha of the land on 17/2/2012. The period of validity of the sanction plan is 3 years as per the bylaws. In the meantime, there was an order passed by this Honorable Court in PIL with respect to various constructions that are mushrooming in the city of Patna. Thereafter,
Is there any renewal provision? 3 years, beyond 3 years?
my lord, there has to be a fresh proposal beyond 3 years, and never such approval was granted, and the concerned person who was the writ petitioner continued to construct despite an order of stay also passed by municipal corporation.
Who has granted stay?
My lord, on 3 occasions. The first occasion was 27/6/2013, which
Who
is
has granted, sir?
municipal corporation had stayed the construction of the building, despite which it has continued and the work has been completed. There are deviations which are found which could have been condoned only if the plan was approved. In this case, the plan has expired. The municipal commissioner has directed that post facto sanction
Examined by the trial court.
My lord, in the before the learned trial court, the issue is different. It is for dissolution of.
Violation of construction is in violation of certain.
My lord, it is with respect to the bad quality of material that the petition for injunction was filed. It is for dissolution of partnership, and with respect to the illegal construction deviation from plan, there is no title suit pending. And Tarun Kumar, my lord, our first submission is that could not have maintained the writ petition because he was the 4th partner of SRM Builder, which was inducted was Surya Nest Build Limited through its managing partner. Tarun Kumar is a managing partner in that 4th partner of the partnership firm. But the partnership firm itself could have maintained a writ application being a different and distinct identity. Tarun Kumar has no personal interest, and he was not the person aggrieved by the order passed by the municipal commissioner.
No, that is the reason. Initially, we asked, what is this locus standi of Tarun Kumar?
My lord, our submission is that he could not have maintained this writ petition because the 4th partner.
But he was party to the tribunal, before the tribunal.
My lord, he was issued notice by the municipal commissioner also, therefore he has responded. But in the personal capacity, he had filed an IA also for transfer.
No, when he has, you are not objected in the initial.
My lord,
before the tribunal.
In the writ petition, he has filed.
Before the municipal building tribunal, have you raised objection stating that Tarun Kumar is not necessary and proper party?
My lord, in fact, before the learned tribunal, we were the appellants. The order was passed.
Then why did you implead him?
My lord, it is basically the Surya Nest Build Limited which was to construct, not Tarun Kumar. So therefore, if by the order of the learned tribunal, it is only the company which is aggrieved party.
how writ is maintainable by Tarun Kumar in his individual capacity?
He was the director of SRM as also Lord Surya Nest Builders, and it was
Correct, but Tarun Kumar in individual capacity he cannot maintain writ petition.
Lord notice was issued to him.
Maybe, sir.
In fact,
See the cause title.
Lord,
In his individual capacity, he has filed writ petition. How writ petition is
Lord,
maintainable?
in fact, he has impleaded Tarun Kumar by name. Kindly see annexure 26, page 131 of the
He
return.
told that Tarun Kumar has no locus.
Lord, Tarun Kumar was made party by him before the municipal commissioner.
Correct, sir. Not in individual capacity. He has impleaded him by that he is one of the partner for measures Surya Nest Builders.
Kindly see annexure 26, page 131 of the writ petition, the party position.
No, we are going by cause title. In the municipal building tribunal,
Yes,
he
Lord.
has been arraigned as a director. Now he cannot maintain his writ petition in individual capacity. As a director, he can file.
Lord, annexure 26, kindly see what he has done.
What is the 26?
Lord, that is the proceeding before the municipal commissioner.
We are not concerned with that, sir. We are concerned with the writ petition is maintainable by Tarun Kumar in individual capacity or not. In individual capacity, he cannot maintain.
Lord, there is a direct because he was the person noticed by the municipal commissioner.
We have to go by cause title.
Cause title.
Before the municipal building tribunal, he was arraigned as one of the director. Come back after 10 minutes.
डायरेक्टिव का किसी बिंदु पर हाइड करना है डायरेक्शन है इंजीनियरिंग सर्टेड पॉइंट से हाइड करने के लिए सप्लीमेंट्री पर्सनली फाइल करना वो जो पॉइंट फॉर्मुलेट फाइल करना है कम्युनिकेट करने के लिए जाना जब वो साइन करेंगे तब ये भी टाइम फिर 2 दिन के बाद देखते हैं इस वक्त और एंड में लीजिए
Shareholder is coming. Basically, respective home rights.
Has been provided comments. Weather petition. जो शोकॉज नोटिस था, there is any proposal for blacklisting for 10 years. उसी में मैंने 1/8/17 में there is any proposal for blacklisting for 10 years. Whether engineer party to verification बस इतना ही नहीं है, तो बोले तो बहुत एक रिक्वेस्ट करेंगे जितना आपके साइन तो आपके हाथ में नहीं है, आप प्लेस कर
Before the tribunal is before the. There is objection will be raised before the single judge. तो पहले नहीं रहता
में कुछ समय हुआ है क्या? सेल में 49 में टाइम हुआ है 2 वीक्स 49 का
सीरियल 56 में क्या हुआ है? सीरियल 56 में सीरियल 56 हियरिंग मेंशन हुआ था अर्जुन के लिए कब रहेगा?
मेंशन हुआ था, कोई आदेश नहीं हुआ, कोई एडजमेंट नहीं हुआ।
आज टेकअप होगा?
नहीं कर सकते।
अच्छा ठीक है।
नहीं सर This is at his instance.
सर एक स्लीपर नहीं दिए थे तेरे उसको एक सुधार करके दे देते चला गया कहाँ गया होगा सेक्शन में
वही ना कौन सा केस हमें केस करना था सोच समझ के लिखना चाहिए सोच समझ
खाली उसका नंबर दिए है और
हाँ तो नंबर दे दिए सब क्या दिए
उसका पार्टी ने नहीं छूट गया था मुझे इसलिए कोई दिक्कत तो होगा नहीं उसमें
सही नंबर दिए हैं ना
हाँ हाँ सही ना
दूसरे का नंबर
ना
Bila kita ambil terawal lagi kan saya isi. Ialah kita ambil.
बाईस तारीख का जो रहता है वो सब उसी डेट में किसी भी दिन रिसीव
Period number 25 to continue.
Yes, sir. Tarun Kumar has no locus.
And kindly see the party position before the tribunal, which order was challenged here.
Yes, sir.
Appeal filed before the tribunal.
Page 35.
Page 35. He is the appellant here. We have filed writ against this order. Shailesh Kumar, son of Bengali Singh, one of the partners of SR versus Patna Municipal Corporation. Number 2, Tarun Kumar, director, Messrs. Surya Nest Builders, one of the partners of Messrs. SRM Builders. And thereafter the
Now, writ petition.
Yes, my lord.
Cost title.
Kindly compare respondent number 2 before the tribunal with petitioner Tarun Kumar, son of Jagdeep so and so.
Correct. In his individual capacity.
Lord, kindly see number 2, director, Messrs. Surya Nest Builders, one of the partners in individual capacity, because there is a partnership dispute.
No, sir. In the writ petition.
Yes, my lord.
In the writ petition, cost title Tarun Kumar, son of so and so. That's all.
And then managing partner, SRM Builders. Managing partner, SRM Builders.
But here it has been shown as a director.
And he is not the managing partner of SRM Builder.
And he has not been shown as a director.
Partner of Messrs. SRM Builders.
But we have to go by the whatever the cost title in the municipal building tribunal.
Therefore, my lord, Tarun Kumar, and for that reason, my lord, only 2 submissions. Number 1, this from the order of this honorable single judge, it does not appear that this point was raised. And in fact, honorable single judge had raised.
Sir, we have to go by status.
We had cited one judgment, which is we will be citing here now. That is AIR 1970 Supreme Court 564. AIR 1970, Supreme Court 564, Rustam Kawasji Cooper.
AIR
70, Supreme Court 564, paragraph 14. It's related to whether shareholders of a company can also have a individual claim. In paragraph 14, the Lordship, Lord.
Shareholder can. Sorry, it is 564.
564. Sattar Supreme Court 564. Paragraph 14. By a petition praying for a writ against infringement of fundamental rights.
No, paragraph 14 is something.
Paragraph 14 at page 585.
Party name?
Party name is Rustam Kawasji Cooper.
Which book? SEC?
No. AIR 1970.
Yes.
Sorry. I'll just pass it on for you. And then another issue which we would be raising is that though the writ application was filed, RC Cooper versus Union of India.
Correct. Para is not tallying because you have SEC, you have AIR.
Paragraph starts with by a petition praying for a writ against infringement.
Very difficult. It is a lengthy judgment.
It is para 12 in SCC, ma'am.
By a petition
praying for a writ against infringement of fundamental rights, except in a case where petition is for a writ of habeas corpus only for infringement of guarantees under Articles 17, 23 and 24. The petitioner may seek relief to respect of his own rights and not of others. The shareholder of a company, it is true, is not the owner of its assets. He has merely a right to participate in the profits of the company subject to the contract contained in the Articles of Association. But on that account, the petitions will not fail. A measure, executive or legislative, may impair the rights of the company alone and not of its shareholders. It may impair the rights of the shareholders and not of the company. It may impair the rights of the shareholders as well as of the company. Jurisdiction of the court to grant relief cannot be denied. By state action, the rights of individual shareholder are impaired. If that action impairs the right of the company as well. The test in determining whether the shareholder's right is impaired is not formal. It is essentially qualitative. If state action impairs the right of the shareholders as well as of the company, the court will not concentratingly merely upon the technical operation of the action deny itself jurisdiction to grant relief. Number one. Number two, though the writ application was filed under Article 226, the Honorable Single Judge construed it to be under Article 227. That is the first line of the impugned judgment of the Honorable Single Judge, and therefore no LPA is maintainable. Kindly see the first line of the order passed by the Honorable Single Judge. We filed an application under Article 226, but the Honorable Single Judge said that no, it is an application under Article 227 in effect.
And whose name the land stands? This land which was gifted?
Beg your pardon? Father had gifted the land to three of his sons, 3 kathas, one of the sons, and retained the rest. And composite development agreement map was sanctioned for 12 kathas.
But for this 3 katha land, which becomes the, whether it was transferred to the partnership?
Yes, my lord. This is all the, both, one fund was founded by the brothers, one by us. We were inducted as the 4th partner.
Is there any document showing it has been transferred to the partnership firm?
But that is their whole case. In fact, Shailesh Kumar had applied for sanction of plan for entire 12 kathas of land. It is not in his mouth to say that 12 kathas were not there.
In order to ascertain right of the respective parties, it is necessary to peruse the revenue document that the subject land is stood in the name of private person, person or in the firm. Where is that?
But in fact, it was in the name of a private.
It is the land belongs to father of the 3 appellants, 12 kattha. 9 kattha father entered into a.
Forget about all those things. As on the date of filing litigation, whether the subject matter of land stands in the name of firm or individual.
The land stands in the name of individual, father itself. if Bengali Singh, father of the three appellants.
Who are there? His three sons?
Three sons are Shailesh Kumar, Mukesh Kumar and Rajesh Kumar, who were respondents in the writ application.
Then how the Tarun Kumar has
My lord, those three sons had formed SRM Builder, which is a partnership to develop their own land. Now, in the partnership, they have inducted Surya Nest Build Limited by reconstituting the partnership. That induction is on 12/7/2013. Surya Nest was introduced as fourth partner of the builder. Builder is SRM Builder. Builder are also the sons of Bengali Singh. SRM Builder was to develop the land. It had three partners who were the sons of the landowner, and those three partners inducted a fourth partner, which is Surya Nest Build Limited. Today, my lord, the position is that Tarun Kumar has completed the construction. All the landowners are ousted. No share at all has been given to anyone. He is taking rent of all the shops which are running in the building. The fact of the matter is that it was Surya Nest who was inducted, not Tarun Kumar. So when he says in the writ petition cause title that he is the managing partner of SRM, it is incorrect. The managing partner, fourth partner who is the managing partner is Surya Nest, of which Tarun Kumar is a director. So he could not have filed the writ application because he was not a partner of SRM Builder. The statement in the cause title is incorrect to this extent. And he had filed an IA for...
And how LPA is maintainable?
My lord.
How LPA is maintainable?
Our submission is that the order was passed under Article 226 of the Constitution of India. The writ
no, against the tribunal order.
Against the tribunal order.
Under Article 227.
My lord, the writ was filed under Article 227 and it is the tone and tenor of the claim which the writ petitioner has raised as well as the order which Honorable Single Judge has passed, which is the determining test. In the present case, my lord, he had prayed only for certiorari for removing the order passed by the learned tribunal. And that is what the relief has been granted by the Honorable Single Judge. There is no further direction to the tribunal. Therefore, in such cases, I would place reliance on two decisions. In such cases, even if the order of tribunal has been challenged, if the order of the Honorable Single Judge has the tenor of Article 226, LPA would be maintainable. The first judgment is Ashok Keja versus Garden Silk Mills.
Give the citations.
My lord. The citation is 2009-10 SCC 584. Paragraph 36, 37 and 38.
2009.
2009-10 SCC 584.
584.
My lord. (36, 37 and 38). If the para 36, 37 and 38, para 36 I will read with your lordship's kind permission. If the judgment under appeal falls squarely within four corners of Article 227, it goes without saying that intra-court appeal from such judgment would not be maintainable. On the other hand, if the petitioner has invoked the jurisdiction of the High Court for issuance of certain writ under Article 226, although 227 is also mentioned, and principally the judgment appealed against falls under Article 226, the appeal would be maintainable. What is important to be ascertained is the true nature of order passed by the single judge and not what provision he mentions while exercising such powers. We agree with the view of this court in Ramesh Chandra Sankla that a statement by a learned single judge that he has exercised powers under Article 227 cannot take away right of appeal against such judgment if power is otherwise found to have been exercised under Article 226. The vital factor for determination of maintainability of the intra-court appeal is the nature of jurisdiction invoked by the party and the true nature of principal order passed by the single judge. Insofar as the present case is concerned, in the cause title of the writ petition, Articles 226 and 227 of the Constitution have been mentioned. A careful reading of the writ petition shows that the writ petition is not confined to supervisory jurisdiction of the High Court. The employer has invoked jurisdiction of the High Court by praying for a writ of certiorari. The prayer clause in the writ application reads, in view of the aforesaid premises, your lordships may be pleased to issue a writ of certiorari or any other appropriate order. The judgment of the single judge is thus traceable to Article 226. The statement made by the single judge in his order that no case for interference is made out under Article 227 of the Constitution is not decisive. And one more decision, Joginder Singh Ji, Vijay Singh Ji versus State of Gujarat. It is 2015 9 SCC page 1.
SCC page 1.
My lord, 15 9 SCC page 1. Paragraph 20, 29 and 30. 20 is a mere reference to earlier judgment passed by the Honorable Supreme Court, and 29 and 30 is the conclusion. No, 29, Honorable Supreme Court has referred to the earlier judgment of Ashok Kejha, which I just cited, and 30 is the conclusion at 26, para 30. From the aforesaid pronouncements, para 30, it is graphically clear that maintainability of a letters patent appeal would depend upon the pleadings in the writ petition, the nature and character of the order passed by the learned single judge, the type of directions issued, regard being had to the jurisdictional perspective in the constitutional context, barring the civil court, from which order as held by the three-judge bench in Radhesham, that a writ petition can lie only under Article 227 of the Constitution. Orders from tribunal cannot always be regarded for law purposes to be under Article 227 of the Constitution. Whether the learned single judge has exercised the jurisdiction under Article 226 or under Article 227 or both, needless to emphasize, would depend upon various aspects that have been emphasized in the aforesaid authorities of this court. There can be orders passed by the learned single judge which can be construed as an order under both the articles in a composite manner, for they can coexist, coincide and imbricate. We reiterate, it would depend upon the nature, contour and character of the order, and it will be the obligation of the division bench hearing the letters patent appeal to discern and decide whether the order has been passed by the learned single judge in exercise of jurisdiction under Article 226 or 227 of the Constitution or both. The division bench would also be required to scrutinize whether the facts of the case justify the assertions made in the petition to invoke the jurisdiction under both the articles and the relief prayed on that foundation. Be it stated, one of the conclusions recorded by the High Court in the impugned judgment pertains to demand and payment of court fees. We do not intend to comment on the same, as it would depend upon the rules framed by the High Court. Now, in the present case, the writ petitioner has mentioned only Article 226 in the cause title, and he has merely prayed for removing the order passed by the learned tribunal, and only that relief has been granted by the Honorable Single Judge. My Lord will see.
Where have you mentioned that writ petition is under 226?
My Lord, page number 1 of the writ petition, just below the case number, in the matter of an application under Article 226 of the Constitution of India. Page 1. And the Honorable Single Judge also has mentioned in first paragraph of the judgment that the application under 227 of the Constitution of India has been filed, but merely because it has been mentioned, my Lord will see the nature of relief claimed and the nature of relief granted. The only conclusion of the Honorable Single Judge in para number 45 of the impugned judgment is that in view of the discussions made above, the impugned order dated so and so passed in appeal case number by the tribunal cannot be sustained. It is set aside accordingly. There is no supervisory jurisdiction either being claimed to be exercised or which have been exercised by the Honorable Single Judge.
Para 6.
Para 45 is the conclusion. At page 24 of the impugned judgment. There is absolutely no direction in the nature of
No, para 44.
45, 44
No, 45
is the
line order. Set aside.
my lord. That is the only order which has been passed.
Where it has been discussed.
First paragraph, first page of the judgment. It seems more, with due respect, my lord, it seems more of a typographical error because the writ petitioner has not filed it under Article 227. And there is no issue decided by the Honorable Single Judge that the writ petition was under Article 227. It is only a mentioning with respect to the prayer which has been made in the writ petition. And in the entire order, no power in the nature of supervisory jurisdiction.
Respondents have filed their counter affidavit. You have filed your counter. Then how can you raise that 227 issue? Because that was not the raised by the single judge.
He has not filed any. He has not raised any of this ground in the LPA. We are respondents in the LPA. He is the appellant here.
Correct, sir. Now you are saying that LPA is not maintainable. Correct.
I am saying that the
LPA is not maintainable. Where is that ground?
Lord, we say that because since the Honorable Single Judge has exercised power.
That is orally you are saying. All right.
And had any direction been issued, it may have been in the nature of 226. But he has interfered with the order of the tribunal. So therefore,
writ of certiorari.
He has
writ of certiorari. Against that LPA is maintainable.
In fact, my lord, if in the power of supervision also, my lord, if the order is set aside of the tribunal.
Only insofar as trial court.
And my lord, so far as maintainability of the writ petition was concerned, there is one more decision of the Honorable Supreme Court, which is 1971, Volume 2, SCC 399.
Writ petition is?
Not maintainable according to me because Tarun Kumar was not a managing director of SRM Builder. It is an incorrect statement. Before I read the judgment, I'll just place one fact. He had filed an IA in the writ petition for transposing respondent number 6 and 7 as writ petitioner. That IA was withdrawn by them. Paragraph number 9, my lord. It was with respect to a disqualification on the ground that the concerned person is involved in another business. Para 9 subparagraph, it is unnecessary. The last para of page 400. Para 9 of the judgment, the last paragraph of page 403. It is unnecessary. Last paragraph of 403. Page 403. It is unnecessary for the purpose of this case to reproduce the explanation. It is clear that this section only covers contracts which have entered into by a person in the course of his trade or business with the appropriate government for the supply of goods to and for the execution of any works undertaken by that government. Dr. Singhvi contended that the supply of electricity would amount to supply of goods. That perhaps is so, but in our opinion, the contract of supply of electricity by the electric supply company may by no means be considered to be a contract entered into by respondent number 1 in the course of his trade or business by reason merely of the fact that he was at the relevant time chairman of the board of directors of the company. It is not possible to describe the business of the company to be the trade or business of the chairman of the board of directors. A company registered under the Indian Companies Act, it is settled beyond dispute, is a separate entity distinct from its shareholders. The chairman of the board of directors of the company, while functioning as such, cannot be said to be engaged in his trade or business as contemplated by Section 9A of the Act. The legal position is so clear that the appellant's learned counsel, after an unsuccessful attempt to persuade us to the felt constrained not to pursue this point seriously.
Stands in the name of an individual. No? It stands in the name of that individual for the points. No, is there any partnership?
Have you filed the partnership deed?
My lord, the reconstitution of deed is on record. I will just place it.
No, not reconstitution.
When
Original?
Original part.
Because we want to examine what are the locus standi of Tarun Kumar with reference to this subject land.
Right.
So subject land stands in the name of an individual. It is, any dispute is between the municipal corporation and the landowner. How this partner will come into the picture? Or is it a public interest litigation?
My lord, I have a copy of the
फाइल कर दीजिए.
deed. The original development agreement was between Bengali Singh and SRM Builder. SRM Builders had only 3 partners, which are the sons of Bengali Singh. He was inducted by.
How Tarun Kumar is related to this subject land?
My lord, because Surya Nest Build was inducted as 4th partner of the developer of the land, which was SRM Builder. Surya Nest was inducted as the 4th partner, and Tarun Kumar is managing.
For SRM Builders, Tarun Kumar is the managing partner.
No, my lord. It is Surya Nest which is the managing partner, and Tarun Kumar is a director in Surya Nest. Surya Nest company is the managing partner.
First title, it has been shown as managing partner.
It is incorrect. One of the ground that writ petition should not have been entertained. This statement is incorrect and not borne out of the record. The deed is there. Who is the managing partner? My lord will find that deed is part of the.
Why SRM Builders has been shown the cost title managing partner Sri Tarun Kumar as a respondent, and he is a petitioner in as a, what is this?
He is petitioner also.
Petitioner. He has been shown as a petitioner managing partner of SRM Builder.
We have taken this objection.
Himself arrayed as a 4th respondent.
That is one of the ground we have taken this objection. He filed an IA for transposing respondent number 6 and 7 to be petitioner. That IA was withdrawn. He has himself arrayed himself as the respondent also while maintaining the writ petition. First of all, he is not.
What happened to that IA?
The IA was withdrawn. It was disposed of.
The result, he will be continued as a 6th respondent.
My lord, in the result, he will be continued, and therefore the writ petition was not maintainable, should not have been entertained.
No, at the best, he is not necessary party.
But
6th respondent.
But insofar as the writ petitioner is concerned, the statement that he is managing partner SRM Builder is incorrect statement. He is managing, Surya Nest Build is the managing partner of SRM Builder.
No, otherwise, what is the status of Tarun Kumar?
Tarun Kumar is a director.
SRM Builder.
In SRM Builder, he has no status.
Where is the material to show that?
My lord,
who are the partners of
my lord, that material my lord will find. I'll just give the page number. Annexure R3/6 in the supplementary counter affidavit filed on behalf of respondent number 3, running page 474.
Now, have you taken contention in the counter affidavit in the writ petition that he is the Tarun Kumar petition is not maintainable since he is not a partner of SRM Builders?
My lord, the contention which we have taken is not exactly that it is not maintainable for this reason, but we have stated that he is not a partner in SRM Builder.
Where have you stated?
My lord.
Counter affidavit by whom? 4th respondent? What respondent? You are Rajesh Kumar?
My Lord Rajesh Kumar. And
Respondent.
this supplementary counter affidavit on behalf of respondent number 3.
No, you are respondent number 4 or?
I am 4. My Lord Shailesh Kumar had also brought on record.
But Rajesh Kumar has not taken such contention.
My Lord, I'll just. Rajesh Kumar has taken a Mukesh, respondent number 4, who is also the appellant with Rajesh Kumar. He has taken a contention that the petitioner has wrongly made respondent number 6 as a party to the writ petition, as there was no such party either before the learned municipal tribunal Patna or before the learned commissioner of Patna municipal. And he has stated that SRM builders in the title suit are being represented by respondent number 4 and 5, and the petitioner, namely Tarun Kumar, has appeared and filed written statement only on behalf of defendant number 1 and 2, MS Surya Nest Build Limited, through its director Tarun Kumar. So we have taken an objection that SRM builders should not be represented by Tarun Kumar in paragraph number 5 of the counter affidavit filed on behalf of respondent number 5. And the partnership deed, my Lord will find, of all the partners, it is annexure R3/6 at page number 5 of the supplementary counter affidavit filed on behalf of respondent number 3, running page 474. All the partners are mentioned here in the deed.
Is a complainant before the Tarun Kumar is a complainant before the municipal authorities?
It is Shailesh Kumar who is the complainant.
Then how Tarun Kumar name was reflected in the?
My Lord will see. The name is reflected as director of Surya Nest Build. He is issued notice to represent Surya Nest Build.
No, at the same time it is shown as one of the partner of Measures SRM Builders.
That is incorrect. Partner, I brought the
incorrect means you have filed the petition before the tribunal.
My Lord, it is Surya Nest who is one of the partner of the SRM.
Correct, sir. You have filed appeal before the tribunal.
My Lord.
In your appeal, cause title reflects that Tarun Kumar is the director of Surya Nest and one of the partner for SRM.
My Lord, he is director Surya Nest, to that extent is correct.
No, why have you implicated Tarun Kumar, Rajesh Kumar?
Nest is one of the partner.
Huh?
My Lord will see. Surya Nest is one of the partner. So
correct. At the same time, Measures SRM Builders, you take page 35.
Surya Nest is partner in SRM. Surya Nest is partner in SRM. Tarun Kumar, in his individual capacity, is not a partner in SRM. Surya Nest is actually a partner.
And why did you make Tarun Kumar partner in this case?
It is only to represent Surya Nest Build Limited, my Lord.
Ought to have written Surya Nest through its partner.
My Lord, that to that extent.
In what manner he is concerned with your property?
He is, since the fourth partner of the developer is Surya Nest Build Limited, and Tarun Kumar represents Surya Nest. He is one of the director in Surya Nest.
No, fourth partner of your, what is that? Your
SRM Builder. Fourth partner is Surya Nest Build Limited through its director Sri Tarun Kumar is the fourth partner.
Surya Nest is fourth partner.
Fourth partner through its director Tarun Kumar in the deed of partnership. But when he files the writ application, he does not file it in the capacity of as a director of Surya Nest Build.
Now, how his right is affected?
That is, my submission is that his right is not affected. He should not have been.
Why did you implicate him?
My Lord.
Unnecessary tangled yourself.
It is only to represent Surya Nest Build whose rights were affected.
How Surya rights are affected?
My lord, because he is the fourth partner in SRM Builder, and SRM Builder was to develop the land, 9 kattha of land. And Surya Nest was to develop 3 kattha of land.
It's a joint venture.
Yes. After 2 years of
24/11/2015, as on this day.
partnership was reconstituted.
What is the benefit we are going to get for partners in the event of huh?
He was inducted and he was having money to develop the project.
No, all right. For him, no. In the for condoning this.
Yes, actually what he is fruit of this venture. He is 70% partner.
Whatever you think, he is beneficiary, no? Because of this. Why he is waiting?
He wanted to oust the 3 partners. Probably
Partnership deed. In other partnership deed, persons and fourth.
this is
Right of the Tarun or SRM builders. SRM builders over the land. Over the land. Share. Consider as good.
70%.
70%. So they have a right.
Surrealist have arrived.
SRM. Surrealist has no locus. SRM has. Correct. Therefore, they have a right. But Surrealist is not. Okay.
This is between this partnership for groups.
Then the fourth one. There is a locus. Oh, it is in his favor. This condonation. Huh?
That's what why he is everything.
But really,
Yes. Why this he was preferred this person will be having 12% share, who's agreed? Both these agreed.
Partnership deed in Three Brothers and Surya. How SRM will come into picture? Partnership deed, there is no role of SRM.
SRM only entitled for the firm.
Huh?
SRM is the name of the firm.
Correct, but how SRM, what is the role of SRM in the partnership deed? There is no role.
The partnership deed was executed to bring on there was no SRM. When this 3% land was given by
Their own firm is SRM.
and that the Madison entered into agreement with this firm for the development of his land.
What is the document to show that SRM builders consisting of who are all partners?
My lord, it is Annexure R3/6 in the supplementary counter affidavit filed on behalf of respondent number 3 in the writ petition. All the partners' name are given.
How to find out?
My lord, running
Bunch
page
of paper.
474 running page.
Huh? Page?
470 running page 474 in the writ petition. Correct.
No, in terms of this, Tarun Kumar is the fourth. He is representing Surya.
He is representing Surya Nest Build Limited as director of Surya Nest Limited, and he says that he is.
Where is this SRM?
It is the SRM
SRM document.
This is the document, my lord.
No, this is not SRM.
This is deed of reconstitution of partnership between first three persons were earlier partners in SRM. They inducted fourth partner.
Where is the first deed?
First one.
When SRM builders was constituted.
At least in this document, where is the pleading? In which paragraph you have stated that earlier so and so were the respective parties and it has been reconstituted, altering these names. Where is that?
My lord.
Constituted with consisting of.
My lord, in para number 13 of the counter affidavit, filed on behalf of respondent number 5. By this agreement itself, he was introduced as fourth partner of SRM Builder.
For what purpose? Reconstitution of this document is for what purpose?
Earlier, my lord, there were 3 partners just to in
Overall?
First 3 persons.
No, there is a fourth man. Surya Nest Build is there.
He has included by this reconstitution. Earlier, it consisted of only 3.
Where is that building in this? Earlier, the 3 persons were there.
My lord,
Surya Nest Build was incorporated.
in the writ petition itself.
Not in writ petition, sir. In the deed.
In
This document.
In this document, my lord will find page number just before serial number 4, Surya Nest Build Limited. Next paragraph. Whereas just below Surya.
Para number?
Para number 4. The sub para of para number 4. Whereas the parties of the first to third part were already in a partnership agreement by virtue of a partnership deed entered into on 7/12/2010 and registered on dated 29 January 2000 wide so and so to carry on business of building construction and other allied work. In the interest of business, it was decided to induct a new partner, namely MS Surya Nest Build Limited, as party of the fourth part.
So first only Shailesh Kumar, Rajesh Kumar,
and Mukesh Kumar. And these persons are also sons of the landowner. And today the position is that Tarun Kumar has constructed and all the rent is being paid to him. We are out of the property.
Writ has been filed in the capacity of managing partner. Yes, sir. We were set aside. Writ petition is not maintainable since Tarun Kumar in the capacity of managing partner SRM Builder has been filed, and he was not a party to the tribunal as a managing partner SRM Builder. He is a partner or a director of Surya Nest.
Kindly see page 35.
Yes, sir.
This is the appeal filed by Shailesh Kumar, his brother. He is also one of the appellants. There are 2 appeals. Page 35 of the writ application.
Yes, sir.
Shailesh Kumar, son of so-and-so versus number 1 Patna. Number 2, Tarun Kumar.
Yes, director.
Director, Messrs. Surya Nest Builders Private Limited, one of the partner of Messrs. SRM Builders having its office at Boring so-and-so.
Now take the cost title of...
Yes, Lord. He has now SRM Builders also had inducted the Surya Nest through its director Tarun Kumar as partner, my lords have seen. And ultimately, my lord, kindly see what has happened now.
Sir, we have to see what is the locus. The Tarun Kumar, he has a capacity of, he had a 2 capacity. One is a managing partner SRM Builder, another is as a director of Nestle.
Yes.
Nest Build. So the Nest Build is the proper party in the appeal. How writ petition can be filed in the capacity of managing partner SRM Builder?
In fact, my lord, Tarun Kumar has been arrayed by name as respondent number 2 before the tribunal in appeal by Shailesh.
Correct. In the capacity of what? One of the partner.
Description.
Director.
Director Surya Nest and one of the partners of Messrs. SRM.
No. That is not the correct.
That is one aspect. The other aspect is, kindly see, my lord, what is the effect as of now. The building is constructed. Title suit is pending for dissolution of partnership and also for demolition. Kindly turn to annexure 21, page 117. I will just show the factual position, and thereafter, my lord, whatever order my lords will pass. Lord, Lord, the dispute is paragraph 3 at page 117. The plaintiffs petitioners have filed the aforesaid suit for resolution of partnership and for accounting. In the said suit, the plaintiffs have also prayed for.
They are not concerned with this.
Demolition of the construction already made by respondents, that is, and in this there is a finding which is not has been challenged. Kindly turn to page.
We are not concerned. We are concerned with whether rate petition is maintainable or not.
We have not invested anything. We have invested out of the 4 partners, and essentially, if the so-called if the writ court order goes, in my respectful submission,
no, we will give you liberty. So far as in the capacity of a partner of Measure Surya Nest Build, you can challenge it.
In the writ petition, my lord, fortunately we had arrayed SRM Builders as also Surya Nest Limited as respondent 6.
We are not concerned with that.
So that
we are only examining the locus standi with reference to parties in the before the municipal building tribunal.
And then, my lord, there is one principle that if one illegal order is set aside and that leads to revival of another illegal order. If by setting aside one illegal...
No, we are setting aside only on the score that you have no locus.
Another illegal...
Capacity of managing partner SRM Builder.
Not that my submission is that if by the order of the writ court, Lord, it has wrongly been entertained and allowed, and that order is set aside, that would lead to revival of an illegal order of the building.
Sir, we are going to give you liberty, challenge in the capacity of Director Surya.
But in fact, Lord, Surya Nest Builders and SRM Builders are also parties to the writ proceeding.
Maybe, sir.
And
maybe because why they have mentioned in the cause title of municipal building tribunal is first they have mentioned director. That's all. The Surya Nest is one of the partner for SRM Builder, not Tarun Kumar.
In fact, Lord, in my respectful submission, had they made Surya Nest developers through its director Tarun Kumar a party, matter would have been different. They have made Tarun Kumar party by name, and therefore a description has been given, which is a secondary.
No, your description is only to the extent of Surya Nest. Director Surya Nest.
The first description is Tarun Kumar. The name
as a director, not individual. Director of Surya Nest Build.
The description, my lord, had it been Surya Nest Build through its director Tarun Kumar, Lord, in my respectful submission, Lord, what my lord is saying would have been correct. But since Tarun Kumar has been made party in his individual capacity,
not individual,
Lord, Tarun Kumar. Otherwise,
sir, director has been shown.
In fact, my lord,
director Measure Surya Nest Build Private Limited.
That is my submission, my lord. And submission number 1 is that Tarun Kumar has been named as party before the building tribunal, and number 2, that in any case, both SRM Builders and Surya Nest Builders were party respondents in the writ application. So far as this issue is concerned.
That's all?
That's all.
It's taken. The instant LPA appellant has assailed the order of the land single judge dated 3/19. Passed in CWJ 9864 of 2007. Brief facts of the case. Bengali Singh was who had given gift of 3 katta land to his son Shailesh Kumar dash appellant herein. Bengali Singh had 3 sons, namely Shailesh Kumar, Rajesh Kumar and Mukesh Kumar. They have constituted a partnership firm called SRM Builders. Full stop. Further, they have entered into development of land agreement the name of SRM Builders to the extent of 9 cut of land to be developed. Appellant Shailesh Kumar proceeded to apply for composite plan sanction and plan sanction and corporation sanctioned the plan. In this regard, there was litigation CWJC 8152 of 2013. And it was disposed on 10/5/2013. With an observation that no construction shall be made in violation of the order dated 24/5/2013, stated to have been issued by the corporation. When things stood thus, appellant for SRM Builders proceeded to reconstitute the partnership deed on 11/7/2013 while giving the large chunk of share of 70% to Surya Nest Build Limited. And they had entered into agreement to stop. Regard, there was certain delay in conclusion of the completion of the construction, and so also there were certain alleged deviation in construction of building. The same was noticed by the corporation, Patna Municipal Corporation, within bracket for short corporation. Corporation proceeded to take action to demolish the building, and thereafter decision of the corporation was revived only to the extent of condonation of condonation and compounding fee. No, while levying the condonation and compounding fee. To that effect, an order was passed by the Municipal Commissioner on 24/11/2000 who is feeling aggrieved and dissatisfied with the order of Municipal Commissioner dated 24/11/2015, Shailesh Kumar, one of the partner of SRM Builders, preferred an appeal before the Municipal Building Tribunal Roman 1, and it was allowed in his favor on 31 May 2017. Who is feeling aggrieved by the order of the tribunal dated 31/5/2017, Tarun Kumar, managing partner SRM Builders, preferred CWJC 9864 of 2017. To the learned single judge allowed the writ petition on 3/4/2019, allowed a CWJC 9864 of 2017 on 3/4/2019, hence the present LPA. Next, learned counsel for the appellant submitted that Tarun Kumar, in the capacity of managing partner SRM Builder, cannot maintain the writ petition. It is submitted that he has been arraigned as Tarun Kumar, Director, Measure Surya Nest Build (P) Limited, one of the partner of SRM Builders, and not as a managing partner SRM Builders, as is stated in the writ petition. Next, it is further submitted that one single judge has committed error in taking note of that writ petition was filed under Article 227, even though a writ petition has been shown as under Article 226 of the Constitution. To that effect, there is an error committed by the learned single judge. Per contra, and counsel for the respondent resisted the aforesaid contention and submitted that Tarun Kumar petitioner was a party before the Municipal Building Tribunal in appeal number 44 (North/2015), decided on 31/5/2017. As he has been arraigned as a second respondent, the capacity of Tarun Kumar, Director, Measure Surya Nest Build (P) Limited, one of the partner of Measures SRM Builders, therefore he is a necessary and proper party, and rightly Tarun Kumar has presented a writ petition in the capacity of managing partner SRM Builders. It is also submitted that the LPA is not maintainable in the light of the fact that the writ petition was decided with reference to Article 227 of the Constitution of India. So, heard the counsels for the respective parties. It is necessary to reproduce the cause title for the Municipal Building Tribunal in appeal number 44 (North/2015). It reads as under. It is also necessary to reproduce the cause title in CWJC 9864 of 2017. Perusal of the second respondent in before the tribunal read with petitioner named Tarun Kumar in CWJC 9864 of 2017. It is totally in a different capacity. On this score itself, writ was not maintainable. Same was not noticed by the learned single judge. Further, it is to be noted that writ petition was filed under Article 226 of the Constitution, whereas the learned single judge has taken note of that as if the writ petition was filed under Article 227. So, we find prima facie it may be a typographical error for the reasons that there is no averment or a discussion of the respective parties insofar as whether writ petition was filed under Article 227 and it has been converted into Article 227 with the learned single judge. The learned single judge has not analyzed whether writ petition was filed under Article 226 or 227. Therefore, one has to draw inference that order of the learned single judge which indicate that the writ petition was filed under Article 227 of the Constitution may be typographical error. Further reading of a prayer in the writ petition, and it relates to writ of certiorari insofar as the question of a order dated 31/5/2017 passed by the Municipal Building Tribunal in appeal number 44/North/2015. Next, in the light of these facts and circumstances, appellant has made out a prima facie case so as to interfere with the order of the learned single judge dated 3/4/2019 to the extent that Tarun Kumar cannot maintain writ petition in the capacity of managing partner SRM Builders. On the other hand, he should have filed a writ petition in the capacity of Director, Measure Surya Nest Builders Private Limited, as is indicated in the cause title of the tribunal, in the tribunal appeal. Accordingly, writ petition filed on behalf of Tarun Kumar in the capacity of managing partner SRM Builders stands rejected as not maintainable. Accordingly, LPA stands allowed writ petition 9864 of 2017 dated 3/4/2019 stands set aside. Writ petition 9864 of 2017 stands rejected, reserving liberty to the Tarun Kumar to file fresh writ petition in the capacity of a Director, Measure Surya Nest Build Private Limited.
Both LPAs are allowed.
And the court has not.
What is the other LPA?
Court has not expressed any opinion on merit.
No, we are not stated anything.
Other LPA is by Sales Kumar, who was the appellant in the tribunal. It is 2 LPAs are by 3 sons, same cause of action.
In the light of order passed in LPA number so and so, connected LPA number so and so, do not survive for consideration. Accordingly, the same is stand disposed of in the light of order passed in LPA number so and so.
दोनों पार्टी अलग-अलग खारिज कर रहा हूँ।
45 में टाइम नहीं ना हुआ।
हाँ दूध होना हो गया इसको हो गया
सारा बुक आ चुका है।
कैप्टन लिखे हैं बाद में कुमार सिन्हा ये तीनों रेस्पॉन्ड नंबर 1 की तरफ से हैं कि 2 की 3 की तरफ से
सेकंड हाफ
कौन लिखते हैं?
नहीं आप किसकी तरफ से हैं आपने वन की तरफ
सेकंड हाफ में बैठेंगे ना
हाँ सर
सर यही कंटिन्यू करेगा।
कोई फायदा
It seems there is an change. Don't go and sit again. It does pretty. Problem. I hear it is also in interviews. Some first fights are being made. Because I am on regular physiotherapy for 10 months. I do half an hour daily.
Yes,
Lord.
Serial number 26, Kamaladitya Construction Private Limited versus the State of Bihar for the petitioner Sri Neeraj Kumar.
Counsel appearing this case is in difficulty.
Huh?
This case may be adjourned for Monday also. Yes. Sir, Kunal Tiwari has to argue this case. He is in difficulty.
He is advocate on record. Me, I am recently.
Counsel for the respondent seeks time. List this matter next week.
Right.
Serial number 37 versus GSCO Infrastructure Private Limited versus the State of Bihar for the petitioner Sri Neeraj Kumar.
Maybe. Lord's application for passing the communication lots contained under annexure. Annexure 1, lots 2 and 3, lots whereby lots the work which was awarded to the petitioner Lord had completed. Completion certificate Lord was issued. Entire payments were made. Now Lords, after a lapse of 1 year, a complaint was filed by a local a member of the Legislative Assembly. On that basis, Lord, some inquiry was held behind the back of the petitioner without informing. Now that inquiry report says that some excess payment was made and some irregularities were committed in course of construction. Then even at that stage, no notice, no hearing was given, and Lords, the department directed the engineer, executive engineer, to recover rupees 5 crore 87 lakhs and odd. And
what is the mode of recovery?
Lords, what has happened, Lord, is that at the stage when this writ application, Lord, was filed, we prayed for passing of that communication. During the pendency of this writ application, out of 5 crore 87 lakhs and odd, Lords, they have recovered 5 crore 50 lakhs from the earnest money which Lord petitioner had deposited in the shape of bank guarantee.
No, that was not settled for 1 year from the date of completion of work.
Yeah. They had not refunded that. Now, my lords, by bringing an IA, we have challenged that part of the order also, and my lords, on earlier occasion by order number 3, my lords, the on-board court by a detailed order, my lords, allowed the IA application for amendment, my lords, and further directed, and my lords, simultaneously proceeding was initiated against this executive engineer, assistant engineer and junior. And in that proceeding, lords, all of them have been exonerated of their charge. So on one hand,
what is the reason for recovery?
The lords is that excess payment was made and some work were not as per the specification.
Arbitration is not there.
No, that was not resorted to. Neither, my lords, at any point of time I was informed.
No, is there any arbitration clause?
There is a arbitration clause, lords.
Then invoke arbitration.
But, my lords, my recovery of 5 crore 50 lakhs without any hearing.
No, we will set aside and permit the respective party to invoke remedy under arbitration.
My lords, they can, but so far my recovery that has been made, that
will be decided by the arbitration.
My lords, that may be decided, but the recovery at this is
not a small amount, sir. 5 crore.
So that, my lord, they should restore that amount because it was.
No, thereafter, if you are liable.
My lord, I will the bank guarantee, my lord, is here. I will keep that bank guarantee alive.
Where is the arbitration clause?
Page 133, my lord.
133.
Clause 25.
Oh, bank guarantee.
What is that? Sorry. We really remand the matter to the arbitration. You go and invoke.
But my lord said to that extent, what I am respectfully submitting.
Or whatever it may be, sir.
But my lord said, when the work at no point of time, the certificate, my lord, of the executive engineer is here that the work was completed to full satisfaction. When, lords, we have brought on the record.
Sorry, sir, we will not. Yes, take down.
And, my lord, this court by order dated order number 3 consider all these aspects. Even, my lords, the plea of alternative remedy was considered, and that was
a dispute in respect of non-performance of duty and withdrawing certain money.
No, but, my lords,
that is the issue.
So that is, my lords, can
that is required to be settled by in arbitration.
But, my lords, that part is concerned. The amount is with it is.
Sir, if you succeed, you will get along with the interest.
Lords, so to that extent, lords, they should. Otherwise, lords,
they will invoke arbitration clause.
But, lords, my amount.
Or their claim 5 crore, you also invoke EMD for refund.
Lords, so my amount is for 1 year they didn't refund. They ought to have refunded.
Sir, claim interest, sir, before the authority.
But, lords,
before the forum.
Lords, I pray that, my lords may direct them to refund the amount, and within 2 months or 3 months arbitration should be done.
No. Yes, take note. In the instant petition, petitioner has prayed for the following relief. The respondent.
Lords, the
respondent should
beg your pardon. Then the order which was passed, which I have challenged by bringing an IA, that should be quashed to that extent. That order should be quashed.
Yes.
Because ultimately they will they have already recovered, they will recover further, then they are also threatening to lodge criminal case.
Yes, take down in the instant petition, petitioner has prayed for the following relief. So petitioner is a contractor who had been assigned certain works which were stated to have been completed. However, despite the fact that the work has completed, the respondents have proceeded to recover a sum of rupees 5 crore 87,73,977 from the petitioner. On the score that petitioner was allowed to draw certain amount, the absence of execution of certain works at the relevant point of time. These are all disputed issues that are required to be settled in the arbitration in the light of clause 25 of the agreement. So clause 25 relates to settlement of dispute and arbitration. Accordingly, the impugned action of the official respondent is contrary to clause 25 of the agreement. Therefore, the petitioner has made out accordingly it is set aside. The impugned orders so and so are set aside
and accepted,
reserving liberty to the concerned official respondent of clause 25 of the agreement for in respect of settlement of dispute and arbitration at the earliest, since petitioner's EMD amount is lying with the official respondent to the tune of about a sum of rupees 5 crore.
50
5 crore?
50 lakhs.
50 lakhs. So, the arbitrator, jurisdictional arbitrator is requested to decide the arbitration case in the event of filing arbitration within a reasonable period of time. The above the questions and dispose of.
That order is unaccepted.
Speaker number 38, Rajiv Kumar Singh versus the State of Bihar for the petitioner Sri Manish Kumar number 13.
Policy decision of the state government below is under challenge.
What is the locus of the petition?
So that is the prime issue, below. It does not have any locus, below. The local self-government is there, below. We have transferred those powers to them, below.
None appears for the petitioners. Prima facie, we find that petitioners have no locus to assign the impugned decision of the state government to stop. In order to give one opportunity, release this matter after 2 weeks. If there is no representation on behalf of the petitioner, matter would be decided with the available records. Is this matter?
Right.
Speaker number 39, Mrs. Jama Durga Travels versus the Union of India for the petitioner Sri Varun Kumar Trivedi.
My lord, I pray for 1 week time, my lord, in this case.
Huh?
Also, the counter affidavit has also not been filed by the respondents.
You have approached this court insofar as questioning the termination notice. How writ is maintainable? During pendency of the litigation, have they passed order? No, or you don't know?
Counter has not come in this case now.
None appears for the respondent railways. In order to give one opportunity, release this matter after 2 weeks.
40 is withdrawn, page number 41 is passed over for the day, page number 42 is passing versus newspaper payment for the business to the same mark.
Pursuant to your lordship order dated 25/2023, Commissioner has filed supplementary affidavit to lordship bringing on record on your lordship as an Excerpt 12 of the supplementary affidavit at page number 5, your lordship.
Where is the online application?
At page number 5, your lordship, of the supplementary affidavit to your lordship.
Which is the relevant column?
In the bottom, your lordship, there is a bid documents written there, your lordship.
Bid documents.
Lordship. And on the next page, your lordship, there is a profile, and thereafter in technical documents other than my documents, your lordship. In this PDF, your lordship, all entire documents relating to 4.4B1 was submitted, your lordship.
Where is that?
On the second page, your lordship, page number 6, your lordship, there is a profile. Thereafter, in next row, your lordship, technical documents other than my documents.
Technical qualification part 1 PDF.
Your lordship. That has been submitted, your lordship. Thereafter, what happened, your lordship?
Where is that PDF?
PDF was along with the application, your lordship.
Correct. We must know, no?
Your lordship, Annexure 13, your lordship.
13.
Extraction of that PDF has been brought on record, your lordship. Annexure 13, your lordship. Next, your lordship. Page number 8, your lordship.
Page number 8 of what?
Supplementary affidavit, your lordship.
So from this, what we can make out? This is some registration document.
Your lordship, so whatever they have demanded, your lordship,
no, they have demanded that
regarding and plant, your lordship.
Mobile laboratory.
Lordship.
Field laboratory.
Lordship.
Where is that?
All document has been submitted, your lordship.
Sir, you must demonstrate that I have a mobile laboratory. Where is that? Vehicle number, this.
That I will do.
Mobile laboratory means it is on the vehicle, no? Installed on the vehicle. Where is that?
Document relating there to annex has been annexed, your lordship.
Where is the vehicle number, registration number?
Vehicle number written, your lordship, BH0 at page number 13 itself, your lordship.
Item number 13.
Your lordship. Annexure 13, your lordship. Page number 8, your lordship. Of supplementary.
It is relating to some registration.
Registration, your lordship.
What is it? Then this is vehicle registration number.
Your lordship.
Where is the laboratory?
On the next
laboratory has been installed on that vehicle.
On the next page, your lordship, also Hindustan Machinery Stores. Annexure 13 are the documents relating to those tools and plants and laboratory, your lordship. And at page number 20 of the supplementary, your lordship, I have also given the list, your lordship. All these are we are having, your lordship. Page number 20 of the supplementary affidavit, your lordship. List of standard tools.
This is road roller. Where is the laboratory? What is page 23?
That is not a specific.
No, this is specification.
Lordship.
See, item number after 4.4b, B1,
Lordship.
name of the equipment for field testing, laboratory as per its highest standard, name of the equipment, everything is given. Where is that?
We have, Your Lordship, that.
Show us, where is that? Along with the PDF you should have produced. Now you can't.
That all documents were submitted, Your Lordship, along with the application, Your Lordship. So a specific that has I have not mentioned in this supplementary update, Your Lord.
Huh? Why? Why you are not mentioned?
I am in the impression that I have used the application form, Your Lordship. Therefore, I could not. So one more opportunity may be given, Your Lordship. Then I will demonstrate that where is my laboratory, Your Lordship.
Get that PDF in pen drive, PDF.
Your Lordship.
Even required for showing that library and avoid that reason. Even what he is showing us is very some. It is a diesel.
Perusal of supplementary affidavit along with the documents, we are not satisfied with the requirement. Reference to clause 4.4 point capital B within bracket small b, again within bracket 1i. Relating to key equipments for road work and field testing laboratory, road/bridge works. Full stop. Land Council for the petitioner is hereby directed to provide pen drive to the other side in advance in order to verify whether the petitioner fulfill the necessary requisites stated in 4.4 point capital B within bracket small b and within bracket 19 of standard bidding document for PMGSY on the next date of hearing, failing which we proceed to dismiss the petition. 2 weeks. In advance you have to provide.
Here for 43, Suman Prabha versus the State of Bihar for the prisoner Sri Sanjay Kumar.
May please, Lordship said heard the matter on the last occasion and allowed the interlocutory application because we had taken this stand that for 4 lots, the petitioner had applied for, submitted her bid for 4 groups. With regard to, despite there was an interim order on 3rd November, and my lords have noticed that interim order, that the reason assigned was that there had been a violation of clause 4.6 of the SBD and 1.3.3 of the ITB that are at pages 53 and 73 respectively. In fact, my lord, requirement as per 4.6, which is similar to 1.33 of ITB, is that there should be a statement showing the value of existing commitments and ongoing works as well as stipulated period of completion remaining for each of the works listed. We had filed an affidavit and this Honorable Court on 3rd November had noticed the judgment of the Honorable Apex Court, and my lords had also pointed out that. But since, despite the interim order, the state has come out with the counter affidavit and the IA has been filed that with regard to two groups, agreement has been executed, that is, it has been finalized. So we are confining ourselves to the two groups for which the agreement has not been entered into and the tender process has not been finalized.
No, where is this 1.3.3?
Yes, my lord. 4.6 of SB is at page 53.
Page
53, 53. Bidders who meet the minimum qualification criteria will be qualified only if their available bid capacity for construction work is equal to or more than the total bid value excluding maintenance. The available bid capacity will be calculated as under, and on the next page, the relevant portion, note the statements showing the value of existing commitments and ongoing works as well as stipulated period of completion remaining for each of the works listed should be countersigned by the engineer in charge, not below the rank of an executive engineer or equivalent. Now, we filed an affidavit that there are no ongoing works, and that is what the Honorable Court on 3rd November will kindly see the order of 3rd November.
No, this is relating to furnishing of ongoing work.
Yes, my lord. And we gave an affidavit that there are no ongoing works. So otherwise we are...
No, where is the prescribed column that you are required to furnish this information?
Page 73.
What you have written in respect of this column?
We have, in reference to this column, we filed an affidavit that there is no ongoing work pending. Page 144.
No, there is the requirement of filing affidavit.
But in fact, this is what, kindly see the affidavit that is at page 1.
No, all right. Where is the requirement in the application form? In the event of there were no work, to that effect you have to file an affidavit.
Because they say that information works for which bids have been submitted and works which are yet to be completed. We had no work pending, so we filed that affidavit. So therefore, my lord, in fact, there was some lacuna in the clause itself, but despite that we...
No, you should have written here itself in the respective column.
Even in it not applicable.
It's not, and that is what we said, the affidavit, and that is what the, that is the reason.
No, you are left blank. You are not supposed to left blank, and this document does not ask you to file an affidavit.
This is the format, my lord. This is the
correct. In the format itself, you are required to fill up. You should have indicated in the format itself that as on the so and so date, I don't have any work.
So that is what we submitted through an affidavit.
You can't leave this blank.
And we submitted that through affidavit, my lord. That is at page 144.
Sir, affidavit, all right. But is there any requirement by the authorities that in the event of you are not undertaking any ongoing work, in that event you are required to file an affidavit?
In fact, not by way of abundant caution, we have
you are not filled up.
Not, in fact,
that's all. Is anything else?
But we have kindly see the page 144. There was no ongoing work. That is what we have said.
All right, sir, but you are not filled up this column.
Lord, in fact, Lord, because it had to be done by the executive engineer, the certification, and that we could not.
Sir, we are bound by the clauses.
Lord,
can we alter this? No. You file affidavit. Filing of affidavit can be waiver of these columns.
Lord, in fact, in my respectful submission, that is what my lord, that decision, if my lords will kindly permit, that Steel Corporation 1991 3 SCC 273.
Sir, this court cannot alter the format.
But
If you allow your writ petition, nothing but altering this column.
फॉर्म का कॉपी नहीं हम लोग रहे हैं हमारा भरा हुआ नहीं ना है तो हमारा भरा हुआ तो नहीं है बस Lord, 1991 volume 3 SCC page 273 paragraph 6. Because if there was no work pending, that is what Lord paragraph.
The column itself you should have typed it.
Because kindly see the requirement was information on works for which enclosed certificate from engineer in charge for value of work remaining to be completed. That is what has not been submitted. Kindly see Lord page 70.
You should have simply stated that this column is not applicable for me because I have not undertaken any work.
Because that certificate, because no work was pending. Kindly see the requirement. Page 73. Not page 73, just for a moment.
Yes.
Just above the last column. Enclosed certificates from engineer in charge for value of work remaining to be completed.
You should have written in the very tabular column that I am not having any work as on this day.
That is what has been submitted on affidavit at page 1.
How many times you want to repeat the same thing, and I am also repeating the same thing?
Lord, paragraph 6.
This was not given, sir. Please give it back.
ये pass on कर दें. If my lords permit, may I pass on this judgment? Paragraph 6. And two works for which agreement has been done, we say paragraph 6.
बैठा दिए
दूसरे वाले दिए थे 2016 का 12 SCC है.
कहा है कहा है
The cited decision, the authority is relaxed. Court cannot relax.
But in fact, the chief engineer himself, we have brought it on record on the supplementary affidavit. In the reply affidavit, he has issued a letter to the concerned executive engineer. But kindly see annexure 2 of the reply affidavit. Supplementary affidavit filed on behalf of the petitioner by way of reply. This has been not annexure 2 internal page 13.
What is that?
Not in that, with regard to the petitioner at page 14, as my lords got it.
What is the date of filing?
Not the date of filing.
Is it 9/2/2023 or 4/2/2023?
9/2. Not annexure 2 starts at internal 13. The letter dated 15th November 2022.
What is this letter?
Lord, in relation to different tenders, including the present one, at page 14, second last paragraph, he has noticed all this, that तथ्यों के आलोक में तथागत कंस्ट्रक्शन प्राइवेट लिमिटेड के द्वारा शपथ पत्र में अंकित कोई कार्य लंबित नहीं है कि आलोक में लंबित कार्यों की जांच कराने का निर्देश अधीक्षण अभियंता ग्रामीण कार्य विभाग कार्यांचल मुजफ्फरपुर को दिया जा सकता है। उक्त जांच के प्रतिबंध के फलाफल के आधार पर अंचलीय स्तरीय तकनीकी निविदा समिति की पुनः बैठक आहूत करते हुए निविदा का निष्पादन किया जा सकता है।
सत्ता है वो अथॉरिटीज, not for this court.
Because the requirement was to give on a separate sheet. If my lords, just for a moment, page 73 may again be seen. Page 73. Lord, just above the last column which is made, with an asterisk, it is written, enclose certificates from engineer in charge for value of work remaining to be completed. So where could I have got the certificate when no work was pending? So
correct, sir. You should have stated in the column itself, stating that a question of producing certificate is not warranted since I have not undertaken any work as on the so and so date.
That is what, instead of certificate from the executive engineer in charge, we enclose the affidavit that there is no work pending.
All right, we consider you are repeating the same thing. We are also repeating the same thing. Indirectly, you are pointing out this is this.
And thereafter, Lord, pursuant to what observations were made in order dated 3rd November 2012, the chief engineer has taken cognizance of that and directed that consider this.
Then withdraw this and pursue them.
My lords may, because we are not, so two have been finalized.
Sir, if you want us to decide, we are going to reject. If you want to pursue before the concerned authority, you are at liberty.
As my lord, we'd like to withdraw with liberty to pursue. In view of letter, my lord, of the chief engineer dated 15/11/2022.
It is left to you, sir. We'll simply withdraw.
But may I only make a prayer so that in view of letter issued by the chief engineer.
Sir, we can't ask them to commit mistake. On their own, they commit mistake. We are not coming in the way.
But then my lords may record my statement that because of the letter of 15th November, I'm not pressing the application.
Yes, take down matter heard at length in the instant petition. Petitioner has prayed for the following relief.
But so far I am concerned, my friend has stated that they are not pursuing against us.
They are disposing, withdrawing. What is learned counsel for the petitioner submitted that he will approach the concerned authority in respect of the relief sought in the present petition in the light of the communication dated 15/11/2022 by annexure 2 to the supplementary affidavit as reply on behalf of the petitioner Full stop. In the light of the aforementioned submission, the present petition stands dismissed as withdrawn.
The interim order stands vacated.
It is naturally when the main matter is disposed.
That's correct, Lord. At times they do not do it.
Stage and counsel for the respondent so and so submitted that interim order is operating and it should be vacated. Full stop. Apex court in the case of Kalabharati versus so and so clearly held that once the petition is disposed of automatically, if whatever the interim order or a direction given by such court merges with the final order.
Apply.
I only make one submission. My lord said written dismissed as withdrawn.
Dispose of.
Nice.
Apply. These are all psychological factors for us.
The chief engineer doesn't understand.
No, we know. We are all. We are myself working as a practicing advocate. Even we were requesting the concerned court to dispose of instead of dismiss.
That's correct. Apply.
Number 44, Satyadev Mishra versus the state of Bihar for the presidency of Power.
Yes, Your Lordship. The counter has been filed on behalf of the respondent number 1 and 2 on the last week, Your Lordship. So my prayer, Your Lordship, the
Last week.
Lordship.
We had sufficient time.
Lordship.
Your writ petition itself is not maintainable. You are asking a writ of mandamus to produce certain documents. You go and invoke RTI. You know, Right to Information Act.
Lordship.
Go and file.
Lordship, there is the provision for the respect of the RTI, Lordship.
Huh?
Yes, Your Lordship, my submission is that, Lordship. I was the petitioner was also the drawn the tender, Lordship.
Sir, whatever it may be, if you are asking for certain document from the official respondent.
I was drawn in the with respect of the tender, Your Lordship.
So what? You go and make an application, sir, under RTI. How writ is maintainable?
Without, Lordship, seeing the notice with respect of the cancelling of the first tender.
You are asking for a writ of mandamus to provide documents in respect of seventh respondent relating to work order and other things.
Reliefs are also, Lordship, the cancel of the.
You want to withdraw? Shall we dismiss? You state down in the instant petition, petitioner has prayed for the following relief. Grievance of the petitioner is relating to providing the work order which were stated to have been issued in favor of a seventh respondent, and thereafter cancel the retender. Able to understand what is this retender notice? So what is the last sentence?
Which was stated issued of seventh respondent and thereafter cancel the retender.
Cancelling of a retender notice, etc. Full stop. In the absence of material information, question of interference with the retender notice dated 22/8/2022. This court cannot interfere with the relief sought. At the best, a petitioner has a remedy before the concerned authority under the Right to Information Act to stop. In this regard, petitioner is at liberty to invoke a remedy under RTI Act to stop. In the event of filing any RTI application, concerned authority is hereby directed to provide the same in accordance with law at the earliest. The above observation, writ petition stands disposed of. Reserving liberty to the petitioner to assign the work order issued in favor of the seventh respondent and consequential orders, if any.
Serial number 45, the Union of India versus Solo Kumar for Exceptional State Karan Verma.
At 4 weeks' time, if granted to file the rejoinder, counter affidavit has been filed.
Counter affidavit?
Has been filed, my lord. Time is granted to file the rejoinder.
For the petitioner seeks time to peruse the counter affidavit. Release this matter after 4 weeks.
The stay should continue.
Huh?
Stay is there, my lord. It should be continued.
Stay is there.
One. Stay is there, my lord. It should be continued till further.
Interim order is there.
My lord. So
Then list after 2 weeks.
my lord, it's a railway matter, my lord. It will take time matter.
Huh? No, compassionate appointment. In fact, I have not noticed that.
Against the railway circular, my lord, that is there.
No, whatever it may be, it is a matter relates to compassionate appointment. You can't drag the matter. Be compassionate towards the litigants.
My lord, then stay should continue for 2 weeks.
Interim order to continue till next date of hearing. It is made clear that no further time would be granted. Get ready on the next date.
My lord, we did it. If no reply should come, then I will place.
Don't wait for reply after reply.
Serial number 46, Messrs. Everest Human Resource Consultants versus State of Bihar.
Lordship, today itself I have received counter affidavit, Your Lordship. It needs a rejoinder, Your Lordship.
For perusal of counter land constant seeks time. List this matter after 2 weeks.
Your Lordship may kindly permit me, Lordship, that it is a matter of blacklisting, Your Lordship. For the
matter?
Blacklisting, Your Lordship. For the purpose.
Government there is no blacklisting.
Your Lordship, this honorable court had made observation that debarment and this blacklisting is similar thing. That is not different things. This honorable court has itself, Lordship.
No, I'm not able to understand what is here.
Lordship, actually, my learned friend is making objection that it is a case of debar.
No, we are not taking up the matter for final decision.
Lordship, may kindly.
Sir, your argument on the next date of hearing. You said
the purpose of yes, Your Lord. I have read the counter affidavit, Lordship.
So, are you ready today?
For the purpose of interim order, Your Lordship.
No question of interim, final. Today itself, ready.
For limited purpose, Your Lordship.
No, why we should all pass interim order? We will decide.
Because, Your Lordship, on the earlier date, Your Lordship had pleased to observe that yes, para 17. In para 17, it was said that the grounds which were taken in the blacklisting order. Those grounds for those grounds and for those facts, no show cause was given, Your Lordship. For against those statements.
So we will allow your writ petition in part. Partly we will allow.
Not a case of part, Your Lordship, because Your Lordship, in day-to-day participation in different tender process, Your Lordship, the petition is getting difficulty, Your Lordship. That's why, Your Lordship.
So get ready.
Next week, Your Lordship.
All right, next week. Next week is a holiday, no?
Next week मुझे Monday को holiday. Monday.
हाँ Monday, yes.
Serial number 47 is adjourned for 2 weeks. Serial number 48, Messrs. JP Printers Court Campus Muzaffarpur versus the State of Bihar for the petitioner Sri Sasi Bhushan Singh.
Finally pass for the day. This is also writ is not maintainable. Writ is not maintainable. Go and apply under RTI, obtain order and then challenge it.
केस कर दिया है another court to engage counsel
Huh?
arguing counsel is another court to engage.
Even if a senior counsel appear in this matter, same order.
Hardly two case.
Why we should give direction to the authorities and furnish the order copy and all? Do you think that we are doing RTI work? Yes, stated in the instant petition, petitioner has prayed for the following relief. The petitioner has a remedy under RTI Act. He is permitted to exhaust a remedy under RTI Act and file a fresh writ petition insofar as challenging a particular order. The above liberty writ petition stand is
Serial number 49 is adjourned for 2 weeks. Serial number 50 is passed over for the day. Serial number 51 is adjourned for 2 weeks. Serial number 52, Mr. Digital Security of India versus the State of Bihar for the additional fee for the last state.
So I'm in serial number 52, my lords. On Friday and Saturday, I've been served with counter affidavit by the private respondent and the state. I seek 3 weeks time to file rejoinder there too, my lords. In the
3 weeks time to file rejoinder, if any.
My lords, in the interim
matter.
Interim order is there.
My lords, the interim order may be continued.
Then 2 weeks only.
Lord, I appear for the respondent. The interim order, Lord, your lordship's interim order is open. There was, Lord, NIT was issued for other places also, to which the petitioner had no concern. He was earlier, Lord, appointed for only...
Make an application for modification of our interim order.
We have filed, Lord, the counter affidavit.
No, modification of our interim order to continue till next date of hearing. Release this matter after 2 weeks.
Deeply obliged.
The area in which he...
Sir, whatever it may be, you put it in writing. Modification of interim order. We will examine.
Grateful.
Serial number 4, who is appearing for 4?
I'm serial number 4, sir.
You want to argue or shall we take up on?
The matter is same. The one thing is that the interim order is not being obeyed by the respondent number 5 because the interim order has been pronounced in the court.
We have just received the copy. Today itself it has come. 4 weeks time be allotted by L3.
2 weeks, 2 weeks, same.
Serial number 53, Sandhya Raj Construction and Services Private Limited versus the State of Bihar for the business.
Lord, this petition has been filed for questioning of the communication dated 6/1/2022, which is contained in XRP 7/36 whereby under even after grant of extension of time in completion of the work, note price escalation have been rejected. Though in the similar circumstances, note I have annexed one order at Annexure 13.
Go and invoke a relevant arbitration clause.
Lord, they have paid the price escalation to other persons which have annexed Annexure 13. Lord, discrimination is being made only because the petitioner has raised the objection with.
These are all disputed facts, sir. You go and invoke a relevant.
What they are saying, Lord, that 5% liquidity deposit which has been kept by the state that has been released. Price escalation would not be given in the case of extension of time. Whereas in the case of some other person, similar to person, Lord, Annexure 13, even after grant of price escalation, grant of extension of time, not the completion of work, price escalation has
not interfere, sir. Not interfere. Where is the agreement clause?
Lord, I have not annexed that agreement clause, but there is no dispute with regard to that, since Annexure P1 is the order whereby they have extended me the period for completion of work on the ground that due to COVID-19, an election held in the state.
Go and approach authorities, sir.
Lord, they have rejected the claim of price escalation. That is, I approach the Honorable Court. I filed the representation, my Lord. That is Annexure 9. And I have given the list of the price escalation that on what count is statement of amount has to be increased, Lord. What they are saying, Lord, in the order that if there will be price escalation in between this period, the lesser amount will be given to the petitioner. If the price would be increased, that will not be paid. That
cannot be adjudicated here in the writ petition. writ petition, disputed facts cannot be adjudicated.
They are not disputing this fact, my lord.
Sir, there is a dispute among you and respondent insofar as escalation of price and neutralization of pricing.
Lord, but they are giving some to some other person, my lord. That is an extra 13 before my lord.
Yes. The arbitration clause are the instant petition petitioner has prayed for the following relief. Perusal of the pleadings read with the relief sought in the present petition, we find that there are certain disputed issues relating to pricing. Therefore, the present petition is not maintainable under Article Constitution. Accordingly, petitions stand disposed of, reserving liberty to the respondent to invoke appropriate remedy. However, in invoking such remedy, the present impugned action would not come in the way. With the above observation, petitions stand disposed of.
Season number 54 is passed over for the day. Season number 55 is adjourned for 2 weeks. The next for hearing season number 56, the state of Kerala and others versus Ram
Maybe, Lordship. In this matter, Lordship, I am appearing on behalf of respondent. Matter is subject to Lordship permissions. I have to respectfully submit that in this matter, Senior Counsel YBC has to assist in this matter. Since the younger brother has expired, that's why Lordship has requested me to pay for 10 days' time in this case.
Yes, who is appearing for state?
Present appeal is directed against the an order dated past
Directed against what?
WGC number 7.
Precisely, Lordship, our case is that we were appointed pursuant to the direction of the Apex Code. And there was a specific direction of the Apex Code that whosoever have been appointed from the approved list of 34,540, they are not required to disturb in any manner. And similar direction of the Apex Code has been reiterated by our division bench that whosoever have been appointed pursuant to the direction of the Apex Code, they are not required to disturb in any manner. In this very matter, Lordship, so far the respondent is concerned, he completed his teacher's training examination way back in the year 83-84, and his result was published as per the direction of the Honorable Court. And even the order of the Honorable High Court has not been challenged ever by the respondent authority. Nor the Bihar Examination Board had ever cancelled our certificate or held fake. Therefore, our certificate is valid for all the purposes.
Where is your order of appointment?
Lordship, it is Annexure 7.
Annexure 7 to the petition.
Lordship, it was issued pursuant to the direction of Apex Code. And Lordship.
Then file a contempt petition. Why did you invoke writ jurisdiction? Why you writ jurisdiction? You should have filed contempt.
Considering all these facts, the Honorable Single Judge has been passed a very detailed order.
No,
these facts are considered.
You are saying that the Supreme Court has given
Lordship, that is the reason
for your appointment.
Has quashed determination order of the petitioner, against which the state has preferred appeal. They have continuously worked, and many of the candidates are still working.
No, you are confusing now. Stating that the Supreme Court has approved your appointment. In that event, if they are taking any contrary decision, you have a remedy before the contempt court of the Apex Court.
That is right, Lordship. But in this matter, my humble submission for Lordship consideration is that our appointments went back in the year 2012, pursuant to the direction of Apex Court.
Where is the advertisement?
So far, advertisement is concerned, I have mentioned.
Your appointment is after due selection process.
Lordship, our candidature was duly scrutinized.
How come at At a time, 34,540 posts of teachers were filled up.
Lordship, there was some dispute regarding the trained teachers' appointment, and therefore the Honorable Apex Court has.
That is the reason we are asking you. Where is the advertisement? Where is the select list? Where is your name?
Lordship, all these Lordship. Lordship.
So we want to make research.
My senior will assist Lordship in that respect. That is the reason.
And counsel for the respondents are hereby directed to produce relevant documents in order to substantiate their selection and appointment to the post of teacher. Similarly, appellants were also hereby directed to prepare a list of dates and events and any documents which are not forthcoming in the records, the same shall be placed. It is made clear that no further time will be granted for the reasons that matter is of the year 2016. List after 2 weeks.
Much.